Welcome back. Shh. Welcome back. Welcome back. Good attendance. Only 5 of you absent. I see you all survived the midterm. I have all of your papers. I will be grading them over the next 2 weeks. My goal is to finish grading them by November 1st. And the review sessions will be starting on, I think I said November 3rd. If you haven't already, please sign up. Almost all the dates on the 3rd are taken. There's some dates in the 4th that are left. Otherwise, you're stuck for the 11th. So it's always better to meet with me earlier rather than later. But same deal as last time. I think I know all of you more or less, so it'll be a little bit easier to meet with you one-on-one. Any questions on the midterm? Yes, Samantha?
And there's no way to verify which time.
You can email me, but it's annoying.
Okay.
Yeah, Doodle's great, but they don't let you see what time you picked. It's a very obnoxious feature of the software. It's not your fault. So before you select the time, just write it down. And if you're not sure, you can email me and I'll check for you. But yeah, that's sorry. It's obnoxious. I wish they had that feature. I don't know why they don't let you review your time, but so here's the thinking. It makes it very easy for you to select a time because you don't have to register and create an account, which is very cumbersome. But the downside is you can't review it. Yeah. Is your hand up? Okay. All right. Other questions? Okay, and there were no issues with the exam. The exam stuff worked. Everything worked okay? Okay, very good. All right. Any questions on covenants? Any questions on covenants? I hope you all figured out the covenant question with the vertical privity on the exam. Okay, hopefully you got that one. I snuck that one at the end. Yeah, there it is. Okay. I did what? Yeah. Okay. Okay. So we're moving on to our next topic, which is broadly described as zoning. Now, you're going to find that this topic and the next topic are different than we've learned before. Why? Because we start doing cases of the U.S. Supreme Court, which is good and bad. The good part is these cases are somewhat more modern. They're not so archaic. They're more understandable. The bad part is the Supreme Court's approach to what's called takings clause is an absolute mess. It's just a disaster. It gets worse. I can teach it, but it's not easy to teach because the cases are all over the place. If everything goes to plan starting next year, the 1Ls will be learning this stuff not in property, but in common law. I think personally, the rest of the semester fits much better in common law that doesn't property because it's not really property law, it's constitutional law. But you're stuck with me, so I can't really change it. By the way, you saw the UB's 2021? So that's not you. So, okay. I don't know if that makes you happy or sad, but at least you have one less thing to worry about. Okay, so for the remainder of the semester, we're focusing a lot on the takings clause of the Fifth Amendment, which again isn't really property, but you need to know it, so here it is. So I want to start off our class with a polling question, please. And here's your question. The government can deprive you of the value of your property without providing just compensation. The government can deprive you of the value of your property without providing just compensation. Okay, see what you guys do with that one. Oh, people are talking. This is an engaging question, huh? Okay. All right, well, let's walk through this one, all right? Who was... Wow, twice in a row. Okay, Samantha. And am I going this way or that way? Okay. Samantha, what do you think here? Okay, why do you think true?
Because if like public necessity comes up, it can outweigh your private interest in your land, so you don't really, you're not really entitled to it.
Ah, so give me an example, something that you probably already studied, where the government deprives you of the value of your property and you don't get paid for it. You've studied this right now, at least in this class and other classes.
Like, I don't know, with westward expansion?
I'm sorry?
Westward expansion, they took people's land without, any justification, just for the purpose of the public need.
No, that's true, but in our class, we've studied an instance where the government deprives you of the value of your property. Notice I didn't say take your property. Look what word I used. I said deprive you of the value of your property. So what's an instance that we study in this class where the government does something, deprives you of the value of your property, and you don't get paid? I'm sorry? Foreclosure? I mean, in that case, it's your fault. You didn't pay your mortgage. But
Okay, I think I'm blanking right now.
Justin?
I mean, using basically requiring that a public roadway go through your land.
Well, again, that's taking your land, right? Notice how I phrased the question, depriving you of the value of your property. Lucas?
Well, if it's going to deprive you of the value of property, I was going to say an applied easement or covenant, because...
Well, again, that's
takes-
taking part of it, though, because you're basically having to give up. I'm saying you get to keep your land and no one gets to come on board. That's my question, right? Give an instance. We studied something like this.
Is it the railroad case? When-
That's not the railroad case. Is that Celeste next up? What do you think?
Well, I can't remember the exact example, but I saw your online class. It said basically that there's the position that states that you have to give you just compensation, something like that. But I don't remember the exact.
All right, let's try this. Who else? Who knows? What am I thinking of? Oh, Kendra?
Are you talking about so something like devalue your property is like if the government says, oh yeah, this factory is allowed to be built next to you, and so therefore now no one wants to buy your property.
Okay. So why might a factory not be able to be built? What about a factory might be relevant? You're on the right track.
Well, I'm saying.
What might a factory do to the community?
Like polluted.
And what do we call that? Ah, the N word. Nuisance, right?
I don't think
Nuisance. Nuisance, right? Nuisance, right? Nuisance. What's a nuisance? If you use your land in a way to injure someone else, the government says you can't use your land in this fashion. Does that deprive you of the value of your property? Absolutely. The most economically useful way to use property is industrial, right? You can either have a one-family home or a two-family home, or perhaps an apartment building. And each of those lands generates more and more money. A one-family home doesn't generate much. With a two-family home, you get more rent. With an apartment building, you have lots of rent. If you have an office, you can make stuff. If you have a factory, you can generate goods, right? As you squeeze more into a piece of land, it becomes more valuable. Now, if the government says, no, 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 you can't build a factory here. Why? It's a nuisance. It'll pollute. It'll make too much smoke or noise or soil the water. The government's deprived you of the value of your property, right? Do they have to pay you for it, though? Right? So, Megan, do you have to get paid if the government says, nuisance, you can't build your factory? Does the government pay you for that?
No.
No. In fact, what happens if you build the factory anyway and you still have a nuisance?
You're probably gonna get some kind of penalty.
Yeah, you pay someone else money, right? So, the answer to this question, right, is true. Okay? Oh, let me stop before people start changing their answers, right? You guys are sneaky. Right? So the answer to this question's, okay, most of you got it, but probably a lot of you would change your answers anyway. I have to remember to stop it. So the answer here is true, but I want you to focus on why. The government can do lots of things that diminish the value of your property. And in most cases, they don't have to pay you for it. Right? We have generally what's called the police power. The police power. You probably learned about this in common law. I had lunch with Alfini today. I'm sure you guys, he's around. He's still floating in the building. He's here today if you want to go see him. So you learn about in common law the police power. The police power, broadly defined, is the ability of the government to regulate the health, safety, welfare, and the public morals of the people. So for example, if you have a factory that's polluting smoke or making lots of groundwater pollution, whatever it happens to be, that can be a nuisance, protect the safety and health of the people. Fine. So you have the police power of the states, which is fairly broad. And when the government exercises the police power, they don't have to pay you for it. Right? When the government exercises the police power, they can diminish the value of your property, but they don't have to pay you for it. But then we have the Fifth Amendment of the Constitution, which applies to the states by virtue of the 14th Amendment. And it says, nor shall private property be taken for public use without just compensation. So for the rest of the semester, every single class will be answering a single question. Is the government exercising its police power, or is it taking property? Let me say that again. Are they exercising their police power, or are they taking property? What's the difference? When there's a taking, right? They got paid, right? When they're taking your property, they have to give you compensation that's just. However, if it's simply an exercise of the police power, they don't have to pay. If you're the government, everything's police power, right? Everything's police power. If you are a property owner, everything's a taking. And the rest of the semester is fitting cases into one bucket or the other. If you're in the police power bucket, that's nice. No money. You'll get paid for it. It's non-constitutional. If you're in the takings bucket, right, they got to pay you for it. Now you're going to ask, Josh, how do you draw the line between a taking and an exercise of the police power? And my friend, it's a blurry line. There's no clear answer. You're going to hate this topic. People always do. But you have to just suffer through the cases, right, of when something's a taking and when it's being an exercise of the police power. All right, so we can get the general gist, right? Think of it as two sides of a coin, right? If you're on the taking side, you got to pay. Flip it over. If you're on the police power side, you don't pay. And that's really the biggest difference for your purposes. Okay, everyone with me? Everyone with me? Okay. The second relevant provision is the due process clause of the 14th Amendment. And I'm sure you say due process at length last year in common law with Professor Alfini. But the basic gist is the government can't deprive you of property, right? They can't deprive you of property without the due process of law. Why does that matter? If the government wants to take away your property, they have to give you some sort of process. But what process is due? You ever wonder what due process actually means? Due process means the process that's due to you. And what process is due varies based on the circumstances. So you have to ask yourself, are you getting the proper procedures before there's a deprivation of your property? The zoning topic implicates both elements, right? First, by zoning land as U1 or U2 or U3, whatever it happens to be, is that merely diminishing the value of your property into the police power? Or is it taking your property, in which case compensation is required? That's the first element. And the second element is, did the government give you adequate process before they deprived you of your property? Was it just some city council made up a statute and applied it retroactively? Was there any kind of hearing? Were you given an opportunity to challenge the zoning requirements? Were there opportunities for variances or perhaps exceptions to this policy? So the case law that develops up focuses on the Takings Clause of the Fifth Amendment and the Due Process Clause of the 14th Amendment. Any exam question from now till the end of the semester, and I mean this sincerely, that involves takings, you should hit both provisions, right? They may not both apply, but at least think through whether they both apply before you only do one or the other, right? I would strongly consider discussing both of them and discuss whether the government has afforded proper process and also whether the government is exercising its police power or cross the line to be a taking. And I would suggest you do both, because I think they're both relevant provisions for this semester. Okay. So any questions on that backdrop, right? Okay. So let me start. I started class here with talking about nuisance for a reason, right? You study very early on in torts, and in this class, nuisance. And with a public nuisance, the government come in and say, you are using your land in an improper fashion. We want to get an injunction to stop it. Or perhaps we'll get damages to compensate for past pollution. And you probably didn't think much of it, right? If someone is engaging in a bad act, you stop it. But if you think about it, nuisance law is responsive. That is, someone did something wrong, and then you're trying to stop them from doing it again. So zoning is responsive. I'm sorry, nuisance is responsive. In contrast, zoning is proactive, right? Zoning's proactive. Zoning is designed to stop someone from doing it before they do it in the first place, right? With nuisance, once they start polluting, you have to run to court and get them to stop it, right? But with zoning, it's saying, no, we're not going to wait until this person starts polluting. We're going to take action proactively, okay? And not only does zoning apply to one person who might be about to build, it covers the entire jurisdiction. With zoning, the government says, we don't want this specific usage anywhere in our community, right? We'll have it somewhere else, but not here. So what zoning accomplishes is almost like proactive nuisance protection, right? It's stopping the nuisance before it occurs by limiting how specific pieces of land can be utilized, right? Now, why is that a significant change, right? Zoning is fairly recent, only in the 20th century came about. Why is zoning significant? Because not every person who builds in a certain area will be committing a common law nuisance, right? The entire idea of a common law nuisance is it injures people, it pollutes, etc. How does building, for example, a two-family house create any more pollution than a one-family house, right? Or how does building an apartment building harm the community any more than, say, building a two-family townhouse, right? The basis of zoning and why it was controversial wasn't so much about the industrial regulation, right? Because they've been regulating industry forever with nuisance. It was regulating the type of people who could live in a community. Understand? It was regulating the types of homes that can be built. And a lot of this actually is based on an apartment, right? The idea of the apartment building was fairly novel for an easy reason, right? Back in the day, you couldn't have tall structures, right? You couldn't have a high-rise. We didn't have the metal to do it. But as you can start building higher structures, you can now squeeze more people into a fixed period of space. And it's no surprise that in some of the cases, apartments are described as parasites. Everyone notice that? Was surprised by that? It's like, whoa, where'd that come from, right? Much of zoning was designed as a way to prevent urban spilling of people into suburban communities. So Euclid, for example, the site of the first case, was a suburb of Cleveland, Ohio. And although the zoning case we have here involved industrial usage, right? They wanted to build industrial facilities. It also applied to residential. So at a very basic level, right? Who am I up to? Chelsea. At a very basic level, what's the effect of saying that in certain areas you can only build one-family homes, and in other areas you can have maybe two-family homes, and the third area you can have apartments? What's the effect of living conditions on that sort of regime? What does that accomplish by segregating zones of how many people can live in a given space?
Distribution of income and wealth.
Yeah, you think you got exactly where I was going with that. Just give me a little bit more, please.
It's so if the book talks about labor and difficulty of procuring adequate domestic service and furthering class tendencies.
Yeah. Yeah, so I mean, it shouldn't surprise you in terms of cost, right? What costs more? A house or an apartment? Well, a house costs more. Why? You need more space, right? More land, more square footage. If in a given plot of land you can only fit one family, it's going to be pretty expensive, right? Just by definition, you need more space for one family. If you fit two families in the same space, then you chop the cost in half. If you can fit four families, you chop the cost into fours. If you can fit an apartment building, you can chop it by 100, right? So the nature of zoning is, I think Chelsea put it well, it affects class segregation. And I think there's a racial component as well. It says you can't live here unless you can afford to buy a one-family home with a huge amount of space. And if you can't afford a one-family home, then you gotta go live somewhere else. Go live with all the other people who also can't afford one-family homes. So the effect of zoning is unmistakable. And we'll do a case, I think, next week from New Jersey called Mount Laurel, which looks specifically at how zoning impacts racial segregation. We'll do that case, I think, next week. But the upshot of the modern zoning scheme is it limits who can live where based on their income. And there's really no other way of describing how it operates, right? If it was just saying you can't build industrial in residential areas, I don't think it'd be nearly as controversial, because we've had nuisance law for a very long time that you can't build industrial next to residential. I think that would probably be okay. But instead, what happens is it's not just you can't build industrial, you can't build certain types of residential in certain areas. And that does have an impact. Right now, the upshot, and the way it's often described, is it prevents congestion, prevents overcrowding, prevents noise. But still, people have to live somewhere, right? You can't zone a person out of existence. So if they're not living in one area, they're living in another area where it'll still be crowded. So what it really does is it separates noise and crowded to other areas that are cheaper to live in. Okay? Make sense? Any questions on that? Just get the basic gist. All right, Rachel, you want to give me, please, the facts in Village of Euclid versus Ambler?
So, in this case, the plaintiff owned land, and the village, which is the defendant, was a residential suburb in Cleveland.
Good.
And then they authorized comprehensive zoning ordinances and proposed a board of zoning appeals to enforce ordinances. Under the regulations, they created these different districts.
Okay.
And they were based on the classes of use, of like how the different land is used. And then because the ordinances that they put into place, the plaintiff's land was partitioned into different uses. And so the plaintiff's land was authorized in like those three different types of uses instead of just one.
Mm-hmm.
And it was zoned in such a way that it disallowed the emergence of industry.
Good.
In it. And then, so the plaintiff sued the defendant, saying that the zoning ordinance constitutes a violation of the 14th Amendment rights and the state constitution, and that the ordinance decreased the plaintiff's land value and dissuaded potential buyers from the area.
Okay, very good. Very good. Thank you, Rachel. So let's walk through how zoning operates. And at least in Euclid, it was a fairly traditional zoning scheme. It operated on 3 different dimensions, right? So the first is what's called a use district, right? A use district. And there were 6 types of use districts. Sorry, not use districts, but use districts. What does that mean? The government said in certain areas, you can only use the property in a certain fashion, right? In certain areas, you can only use it in a certain fashion. And they divided the land up in U1, U2, U3, U4, U5, and U4, no, U6. The upshot of how this works, it works like a pyramid, right? At the top of the pyramid, U1 is single family homes, right? Single family homes. They had to have a basement, at least 3 bathrooms, at least 3 bedrooms, and a bathroom. Why does the government care if a single family has a basement, 3 bedrooms, and a bathroom? Joey, why do they care if a house has that many bathrooms and bedrooms and basements, all those other sorts of things?
They were talking about how they wanted it in that area because it would help preserve the property value and keep every. Honestly, I don't know. It kind of got confusing.
Well, just as a general matter, why would the government care? Why would the government care, Joey, if a house has 3 bathrooms, 3 bedrooms, a bathroom, and a basement? I mean, why on earth would the government care about that? You actually gave the answer. I don't think you realized it, but you actually gave a good answer.
It's to protect everybody of the same type. It's to protect their property rights, their value in land, because if you allow something to come in that's out of the status quo, then it's going to decrease.
Okay. I think you hit the right answer. Everyone heard what he said, right? Much of what zoning law is designed to do is about preserving property value. Preserving property value. But specifically how? By making sure that all the homes in a certain area are of a similar value. You understand? That you can't build cheaper properties in a given neighborhood. So if everyone has similar property values, then property values won't go down. Now, we all know markets are fluid, right? Property values go up and down due to a lot of factors. This is not exactly a science of how to keep property values up. We'll get there next week when we do aesthetics, where we can use zone something based on how it looks, right? You can't have ugly houses. Who decides what ugly is? But these homes, single family, basement, 3 bedrooms, and a bathroom, is designed to say you need at least a pretty big house. Now, what if it's just you live there with, a married couple and 1 child? Do you need 3 bedrooms? Maybe yes, maybe no. Maybe only can buy with 2. What if you have a couple with no children? Do you need a 3rd bedroom? What if it's just 1 person living there by himself? Do they need 3 bedrooms? But this forces you to pay for real estate development that you may not need for the express purpose of keeping the values up. And when you keep values up, you keep out people who can't afford those prices, right? It all builds together. So it's not like, inadvertent. It's as they say, a feature and not a bug. Okay? So you have in U1 single family homes. Okay? But then you have U2, which is 2 family homes. And in 2 family homes, you have to have a basement, 4 living rooms, and a bathroom for each family. So understand, right? The single family home is 3 bedrooms for one family. And then the 2-family homes are 4 bedrooms for 2 families. So just think about that, right? One family gets 3 rooms in the first property. And the second property, a family gets 2 bedrooms. Condensing. The idea is it's cheaper now, right? So now if you have, just a person with 1 child, that might make more sense. It's more affordable. But you have different areas. So let's say that the U1 is like the cream of the crop, the nicest area in town. U2 is going to be not so nice of an area. And the way it works is like a pyramid. In the area zoned U1, you can only build single-family homes. In the area zoned U2, you can build 2-family homes or 1-family homes. Right? You can always go down the pyramid, but you can't go up the pyramid. In U2, you can build U1 or U2 in them. Right? You can build anything you want. Single family or double family. One second. Now, why would you build a single family home in an area zoned for 2 families? The land's probably cheaper. Land's probably cheaper. But, and here's the big but, your property value is not as stable because you're surrounded by all these lower income people. And again, there's no blunt way of saying it. That's exactly how this designs. Yeah, Aaron?
Is the single-family home limited to 3 bedrooms?
I'm sorry?
Is it limited to 3
There's no there's a floor, there's not a ceiling.
Okay.
So you can go bigger.
Okay.
Now, there might be a restriction of how big a house can be in terms of height and stories and number of square feet and the like. But usually, you can always go bigger, but you can't go smaller. And just to Aaron's point, if you want to go bigger, you might need more acreage, right? Because you're required to have a certain number of feet in your front yard, a certain number of feet in your backyard. And if your house is too big, you don't have enough frontage or backage. So you might need a bigger lot to get a bigger, more than 3 or 4 bedrooms. Mm-hmm. Right? Usually, communities don't have a problem with people building more stuff as long as it's spacious enough. But then you have to buy the land. And you pay property tax not by the acre or by the square foot. So you're actually paying more money for having a bigger lot. So the government's always happy with more, just not less. Okay? Oops. All right, so I'm okay with U1, U2. All right, so we get U3, the parasite, right? Every time I realize, like, wow, that's pretty intense. U3 is what's called apartment houses, which also includes hotels, schools, houses, libraries, etc. Okay, with apartment houses, there's not really a limit on how many people you can squeeze in there because you can build up, although there are limits in height. What's the upshot of this? People who want to live in a neighborhood with 1-family homes don't have to live near apartment buildings. People who want to live in areas with 2-family homes don't have to live in apartment neighborhoods. But if you can only afford an apartment, guess what? You're probably not living next to people with 1-family homes and 2-family homes. Right? Again, it goes down the pyramid, not up. So let's say you have a U3 zoned area. You can build a 1-family home there. You can build a 2-family home there. But you can only build it in that area. You can't build it going up. So the effect of that is in most areas with apartment houses, it's going to be almost all apartment houses for residential communities. All right, so any questions then? Any questions? Okay, after this it gets a little bit simpler, right? So far, basically, we've only regulated people. And there's no allegation that people are nuisances. Well, I mean, people might be annoying, right? But a person is not a nuisance in the common law sense. Why does the government have an interest in telling people, if you want to have this many rooms, you live here, this many rooms, you got to live there, right? Gabe, what's the government's interest in separating people based on how many bedrooms they have in their homes, which is really the number, right? It's how many bedrooms you have. That's the magic number, right? What's the state's interest here, Gabe?
Control the population and the amount of traffic that's going in and out.
Well, controlling traffic, but couldn't they do it in other fashions, right? By having bigger roads or more public transportation or different things short of telling people where to live, right? What's the government's interest here? We already said it, but I want to make this point a little bit more bluntly. What's the government's interest here? Ultimately, yes. The only way to actually justify this as a logical matter is controlling property values, right? They'll say noise and congestion and things like that. But you can always take care of that in other fashions, like public transportation or bigger roads. You can always handle it. So the primary reason why governments today defend this sort of zoning based on property, one family, two family, three family, is to preserve property values, right? That's the primary goal. Now, is that to bring you back to con law, is that a legitimate state interest? Is it legitimate for the government to separate people based on how they may contribute to a tax base and property values? Well, the court in Euclid said basically, yeah. All right. So let's just run down the list, and I'll run through the rest of it quickly. The rest of it's pretty more straightforward. U4 is commercial. I'll just call it commercial light, in that you can have banks, offices, restaurants, and theaters. These are sorts of things that people will actually use in a given community. So you'll probably want them close by to have a bank or a theater or whatever else. U5, strange, billboards and advertising. Never think about this, but you can't have advertising anywhere you want. If you think about it, right? When you have billboards, usually on the sides by highways, and they're put in specific locations. In the 60s and 70s, there was a huge opposition to the idea of a billboard. Lady Bird Johnson, who was a former First Lady, that was one of her missions, right? To make the highways clean, so you don't have this visual pollution. It was the thing. And U6 this is the the dirty stuff, right? Sewage, garbage, scrap. Also insane and feeble-minded institutions. We'll come back to the topic a little bit later this semester. And then U7, all use is prohibited. Okay. So which of these types of property can generate the most economic activity? U6, right? A factory creating stuff, right? Those are usually the most profitable per square foot. Which are the least profitable? Single family homes, right? If you just have one family living there, it's not generating that much money. But the way this pyramid works, if you want to build a single family home next to the warehouse, Godspeed. But most people will not do that. Or you might have trailer parks, for example. Mobile home parks, I should say, I'm sorry. If you want to build a factory in an area that's zoned U1, you can't do that. That's prohibited. So again, with nuisance law, you're reactive, right? You're responsive. You're stopping an existing nuisance. But with zoning law, you carve out these use districts in advance, proactively saying, we don't want to risk having a nuisance. We're going to have these areas for residential and these areas for commercial, and we're going to chop them up along the way. Is there any questions in that general frame of how the use districts operate? That make sense? Okay. There are also height districts, which are basically the same gist. In certain areas, you can only go 2.5 stories. In certain areas, you go 4 stories. And in certain areas, you go 80 feet. This is a reflection for basic apartment buildings, right? If you limit a one-family home to 2.5 stories, that might be like a 2-story house with an attic, right? 3 bedrooms, white picket fence, sort of thing. Then you might have a 2-family townhouse, which might be 4 stories, a little bit skinnier, and then you might have an apartment building 80 feet high. You also have area districts, which say that the single-family houses must have at least 5,000 square feet, which is pretty big, and then the smaller areas are 2,500 square feet, and then maybe an apartment might be 900 square feet. So each of the different zoning areas restrict how much square footage you can use. And again, as you increase the amount of square footage, the value of the property goes up, and they charge you more property tax. Okay. Everyone get the idea, the general use? All right, so Daniel, let's go back to Euclid, right? I think Rachel said it right, but we'll just refresh your memories. Describe for me, please, the situation of the property dispute in Euclid with the property owner, please.
So the tract of land, they crossed over 3 different tracts.
Okay. Okay.
And the majority of it was in U2.
Uh-huh.
The next 130 feet was in U3, and the remaining was in U6.
Okay, very good. Thank you. All right, so this diagram on the board describes it pretty well. You had a single tract of land. The part closest to the railroad was U6, which is basically industrial, factories, whatever. And then there's this little skinny lot here for U3, right? And then a little bit of a thicker lot for U2. So Michelle, let me ask you this question. Let's say you want to build the entire tract of land with the same type of construction, right? What is the most likely usage you would put in all three lots if you want to build all three the same?
The U6 uses the industrial.
Could you build U6 over here on the U2 lot?
Oh, just kidding, no.
Yeah.
The other way around.
Yeah, good.
So you would build the single family home.
Well, what's U2? Thanks, Dan. Right. Very good. Thank you, Michelle. Yeah. So if you want to be consistent, right, you could build a 2-family residential community throughout the entirety of this tract of land. But Michelle, does that make much sense? Would you want to put U2 right next to a railroad tract?
Not want to do that.
No. Why not?
Just noise.
Yeah. So the problem with this zoning decision, right, is it makes no sense, right? Why would the exact same plot of land be U2, U3, and U6, right? And also, look at this little skinny thing. You can't build anything there. You make a little apartment building like this tall, right? You can't. And you can't build an apartment building on this lot because it's U2. So basically, this entire middle strip is useless. And I suppose you could build industrial here, leave this one empty, and put 2-family here, but then you have basically houses across the street from the warehouse, the factory. Does this make any sense? Right? Sorry. Zach, yeah. So Zach, does this make any sense? The way the city drew this up?
Well, I mean, it kind of you can kind of see where the idea came from, because it looks almost like they're trying to, you know, keep, they're trying to zone it like from the railroad. So like you were saying, you wouldn't want to have the residential close to the railroad as you go. But once it gets put onto a lot, it doesn't really make sense.
Okay, so we have to ask ourselves 2 questions, right? So Anne, the first question which the court sort of addressed is, what sort of process was given before this zoning map was drew up? Was there a hearing? Was there a trial? Was there any sort of proceeding in a court where they could challenge before the zoning ordinance was drew up and the way they chopped up his lot?
I believe there was. Wasn't there a hearing?
Well, at what point was a hearing brought? Before or after the zoning map was drawn?
Oh, well, it was drawn and it was brought up for comment, right?
It was brought up for what?
Comment?
Is that how this litigation began? How the litigation began, Anne?
Well, they adopted it and then sued.
Yeah. So just answer the chronology. You said it. The city adopted the plan and then they sued. Was there any sort of process before the zoning lot, before they chopped up his lot?
Obviously not one that satisfied him.
Yeah. Well, very good. No, I think it's a good answer, actually. Very good. So just think about this for a minute, right? The city had some sort of vote by the city council, and they adopted a zoning map. They adopted a zoning map. They didn't give him any sort of trial or hearing beforehand. They sort of said, we're adopting this. And he said, no way, I'm going to court. So it's his obligation to sue. So another difference between nuisance and zoning, right? A difference between nuisance and zoning. With nuisance, the government brings the litigation, right? The government seeks to stop and enjoin a public nuisance. But with zoning, who has the burden? The homeowner. The homeowner goes to court to stop the enforcement of a map that's already drawn, right? The homeowner didn't have a process in drawing the map. But once this map is drawn, he goes to court to try to stop it. So a big difference with zoning versus nuisance, the government brings the litigation, and with zoning, the private owner has to bring litigation after the fact. So was the owner here given any sort of process before his property was deprived? The answer is no. But the court doesn't mind because they uphold the notion of zoning in advance, right? They say that the notion that you can have zoning in advance is fine. But the more difficult case is not the due process clause, but it's a takings clause, right? So Joyce, does a court find that there's a taking here in violation of the Fifth Amendment of the Constitution?
No.
Why no?
I think because they talked about like rational basis, and it could basically just like do.
Joyce, what's rational basis? Use a very good phrase. What's rational basis mean?
It's can I go on it?
No. Not in this class.
It's like when I guess the court will weigh I don't know.
Sidra?
That it like basically it made sense for them to enforce that zoning law.
Does rational basis mean the government had a persuasive reason?
No.
No. Thank you. Yeah. So the phrase rational basis, I'm sure you say this in common law, has taken on a lot of meanings over the years. At least in the 1920s, rational basis meant they had some sort of reasonable basis that made sense. In modern doctrine, rational basis means conceivable basis, that there's some conceivable reason why they may have done this. But at least in the 1920s, that the government put forward a reason and it makes sense. For example, preventing overcrowding, right? Preventing congestion. That maybe in a rural community this wouldn't make sense, but in a suburban community it does. Now, the question that Jenica is this map is ridiculous, right? U6, U3, this little skinny piece, you can't build an apartment building, this little slot, and then U2. Is the court going to scrutinize carefully why they drew the line here and why they drew the line there and this line and that line? Are they going to scrutinize carefully how they drew these lines?
No.
Okay, why not?
Well, what I understood, they looked at it, and then they said that because of the whole police powers, that it was for basically the health and the safety and the public good, essentially.
Very good.
And so they said that there was no need to do that.
Very good. Thank you, Jenica. The court's not going to closely scrutinize why they drew the lines where they did. The basis of rational basis is one of deference. The court will defer to the decisions of the elected branches of how they draw up property lines. And so long as they're going to defer, right, they're not going to question why U3 is here and why U2 is there and why U6 is there. That's not for the court to do. It's subject to the democratic process, right? So long as the exclusion of facilities bears a, quote, rational relationship to health and safety, the court won't intervene. This can protect children, extinguish fires, reduce street traffic, make it easy to repair streets. So the court does not have a problem with that. They say that there's painstaking consideration by the government. And very often the apartment house is a mere parasite, constructed to take advantage of the open spaces and attractive surroundings. Okay? Therefore, this is within the police power. And because it's within the police power, it's not a taking. Again, these are two sides of the same coin. If the court finds that some regulations in the police power, it's not a taking. Therefore, there's no compensation required. So at bottom, the court held that he got all the process that he was due. There's no violation of the due process clause. And that this was an exercise of the police power. Therefore, there's no taking. But one note, right? This is what's called a facial challenge. Marcos, you know what a facial challenge is?
No.
Anyone know what a facial challenge is? I'll come back to you. Yeah, Aaron?
It's on its face
Yes. This is a case where the court challenged, the plaintiff challenged a statute on its face. That is, in all aspects, the statute's unconstitutional. Courts do not like striking down laws on a facial challenge because there might be some circumstance where it is constitutional, and there might be some circumstance where it's not. So the court rejected a facial challenge here. Marcus, you know the opposite of a facial challenge?
The opposite of a facial
Yeah.
challenge. Well, facial challenge is when you challenge like a regulation on its face.
Yeah.
I guess the opposite would be where you actually take an in-depth look of what it actually means and like the past legal or past legislation or the past, rulings on that specific case.
Specific, there's your keyword, as applied, right? Very good. The opposite of a facial challenge is what's called an as-applied challenge, where you challenge it as applied to a specific property dispute. And the court here doesn't say you can never challenge zoning ordinance as being irrational, but just you can't do it here in a facial challenge. So the court actually leaves open the possibility that there might be a future case where there's a specific as-applied challenge for zoning ordinance, but this is not it. Now, it's hard to overstate how significant this case was, and the book gives a little bit of the history. The case was originally argued, and looks like the property owner was going to win. But then the case was re-argued with the brief filed by this property zoning guy, and Chief Justice Taft found it persuasive. The court came out the other way. If this case had come out the other way, almost all zoning laws would have been unconstitutional. They all would have toppled one after the other. This was probably the most significant case of the 20th century that no one knows about. It's a very important case because all modern land uses is premised on having this U1 through U6 sort of zoning. Indeed, it's actually called Euclidean zoning. Euclidean zoning, and it's named after the village of Euclid. And the reason why this name is very apt or appropriate is Euclid was the father of geometry, was a Greek philosopher, a Greek mathematician. So it's called Euclidean zoning. And that's what it's called today. Okay. Now, today, almost every state in the union has zoning. Let me explain this point. States have a police power. A city like Houston or Dallas does not have a police power. So what happens is states enact laws that enable local jurisdictions to zone. And these are called zoning enabling legislation. Zoning enabling legislation. And it does exactly what it sounds like. These laws, which are passed by the states, enable local jurisdictions, like a city or county, to zone. Okay? And that way, generally speaking, the zoning laws in states are mostly similar one to the next. All right. All right. So any questions on that? You'll do much more of the zoning legislation next week, or next class. All right, so let me talk a little bit about Houston, our fine city. So I'm sure a lot of you have heard or read at various junctures that Houston has no zoning. And that's technically true. But Houston is somewhat unique in that they've done things that approximate zoning, that are similar to zoning. And I'll give you a few examples. One example is in Houston, you have minimum lot sizes, right? Lots, at least within the 610 loop, have to be a certain size. The effect of that is you can't have small houses. You can have a tiny house with a huge backyard. So by forcing people to pay for more land, it increases the price of property. And then that actually drives up more likelihood you have a single family versus a two-family home. Another restriction is a very Houston thing, is actually a parking requirement. You may not know this, but in Houston, for every 1 bedroom in a house, there must be 1.25 parking spots, at least in apartments. In commercial establishments, for every number of square feet, you need a certain number of parking spots, right? Why is this important? Well, we have no meaningful public transportation in Houston, at least maybe we don't, I don't know. But you have to have a certain number of parking spaces, which increase costs, increases more space, spreads things out. Another aspect of Houston that's somewhat unique is you have to have very wide streets. And again, this is a function of the dependency on cars. So I remember when my parents first moved to, when I first moved to Houston, my parents came to visit, and they were staying by the Galleria, and they tried crossing Westheimer by the Galleria. I was like, no, you can't do that. It's like 16 lanes. I don't know. I think it can be done, but they tried it. Just go across from the mall. But we have very wide streets. Another aspect of Houston law is just to have long blocks. Long blocks, Westheimer, for example, makes it very hard to walk because you have to basically walk 15 feet across the street. You can't really cross the middle of the street. Another aspect of Houston law that's somewhat unique is that the city attorney can enforce private covenants. Right? So generally, if you have a restrictive covenant, a deed-restricted community, only the neighbors can sue for an injunction if it's being violated. But in Houston, right? But in Houston, the city attorney can intervene and actually sue to enforce a covenant. Okay? So even though Houston has no zoning code by itself, it has lots of things that resemble zoning. And these are things that have the effect of promoting cars over public transportation and also spreading things out, what might be called sprawl. Okay? Any questions on that? Now let me talk briefly about the never-ending saga of the Ashby Highrise. I'm assuming, have you all seen these signs? If you drive around Rice Village, you've been there like forever, right? I've been teaching on this, my 7th year. This case has not gone away. It keeps just mutating into another, like this monster, right? It just keeps, look at this, stop the tower of traffic, right? These people are very, very, thank God. Anyway, so let me give you the backstory here. I'm from New York. I hate going back. I'm going back there on Thursday. Ugh, everything's so complicated there. What? Nothing? I hate New York. I love my family. I love going there, but it's so annoying to travel there. So here's the backstory. Houston has no official zoning code. So if you have an area that's all one-family homes, which is what Rice Village looks like, and you want to build that, a high-rise, mixed-use property with apartment buildings, condos, and some sort of restaurants and markets in the ground floor, there's nothing stopping this, right? It's not like you can say this area is U1, and by making it U1, you exclude all apartment buildings. Houston does not have that. So about, oh God, maybe 2009 or 10, I can't remember what year it started, a developer said he wanted to build a structure that looks like this in West U Memorial, Rice Village area. The neighbors freaked out, right? Why'd they freak out? First, they said that there'll be an influx of traffic because, yeah, so see the sign, right? You think traffic's bad now, right? It's Tower of Traffic, they called it. They said, well, if we're having all these people living there, it'll create lots of new cars and create lots of traffic. So they had a traffic study done, and that took like a couple years, and that didn't go anywhere. Then they said, oh, it's going to block sunlight, right? It's going to block sunlight and see the shadow, right? That's their artwork. And it's going to cast a shadow and block sunlight for maybe 3 or 4 properties in the neighborhood, okay? And that went a couple years, okay? Finally, after everything, the city said, okay, enough. Go and build your damn property, right? Build your thing. And at the last minute, the neighbors sought an injunction in court. And the neighbors claimed that the Ashby Highrise was a nuisance. A nuisance? Well, it wasn't blocking sunlight. It wasn't polluting. There wasn't any noise. There was not any extra traffic. What was the basis of the nuisance? The basis of the nuisance was this. It was out of place. It didn't belong. Everything else was one-family homes. And this was a high-rise apartment complex. And they claimed it was a nuisance to be out of place. Now, you guys studied nuisance in tort law. I think you studied in my class. I'd never seen a nuisance like that before. That's a new one for me.
How come they didn't argue that maybe it just raised the property value? Because wouldn't have them building that raises their property.
Probably drops it.
Like their property taxes, I mean. Wouldn't that raise their property taxes?
I don't know if it would raise or drop. I'm not sure. If anything, I think they didn't want it because they want to keep a one-family home. Like, think about it. On this one lot, you can have a single house or you can have a high-rise. I think they wanted to have one-family homes, keep it residential. But good question. So the argument they raised was it's out of place. And, you know, I was actually surprised that they brought a nuisance suit. But I was even more surprised when the district judge actually ruled in favor of the developer, of the neighbors. And the trial judge said that, yes, in fact, it's a nuisance. But then it got weird, right? Generally, what's the remedy for a nuisance? Injunction, right? Do not build. Don't build. But here he ordered damages as a remedy. And the judge said, I'm going to calculate how much having this in your neighborhood diminishes your property value by, and you get a one-time payment. So the neighbor suing got a one-time payment for the diminution in value of their property. And at that point, the developer can build. It's boomer, right? It's like boomer, right? If there's a nuisance to be had, instead of issuing an injunction to stop the cement factory, just pay them to pollute. Pay them to build this high-rise. Now, that was the upshot of the case, basically, that you can pay someone to build a property. Now, I think it's wrong. I don't think it's a nuisance. I think it's completely incorrect. But to the extent that it is a nuisance, you can basically pay people to diminish the value of their property. If they sell it, they've already recouped their value, and someone moving to the neighborhood can consider, do I want to live next to this high-rise? Now, that was like in 2015. I have no idea where the case is, right? Texas courts move very slowly. I don't know where the hell the case is. I think it was appealed. I have no idea. But I do know the lot's still empty. I drive by there all the time. There's nothing going on there. It's been empty now for 8 or 9 years, right? They cleared it in like 2012 or 13 when I first was teaching there. I remember there used to be old apartments here. They cleared them all out, and now the lot's still empty. Okay. So any questions on that? All right. That's all I have for today. Enjoy your day. Stay dry. I will see you on Wednesday.